Have you ever looked at an HR certification exam question and thought, wait, is this FMLA, ADA, ADEA, FLSA? If all the employment laws seem to blur together once you're taking the exam, you're definitely not alone. Employment law questions are one of the biggest reasons candidates struggle, not because the laws are impossible to learn, but because the exam often presents several laws that all seem like they could apply. The good news? You don't need to memorize every detail of every law. In the next few minutes, I'm going to show you a simple framework experienced HR professionals use to quickly narrow down the correct law, often before they even look at the answer choices. Once you learn this approach, employment law questions become much more manageable. Let's get started. Imagine you're reading an exam question. An employee has been out recovering from surgery. Now they're requesting additional time off. They can't perform all of their normal duties, and payroll is questioning their exempt status. Immediately, your brain starts bouncing between FMLA, ADA, and FLSA. Sound familiar? Here's the important thing to remember. Exam writers do this on purpose. They're not simply testing whether you've memorized employment laws. They're testing whether you can identify the real HR issue hidden inside the scenario. That's exactly what HR professionals do every day. Instead of asking yourself, which employment law do I remember? Ask yourself this: what is the employee actually asking for? Think like an emergency room triage nurse. Before diagnosing a patient, they first determine what kind of problem they're dealing with. Do the same on your exam. Identify the issue first. Then, identify the law. We can organize employment laws into 6 simple categories. Once you know the category, finding the correct law becomes much easier. Category 1. Pay. Is the question about overtime, minimum wage, exempt versus non-exempt status, hours worked, or child labor? Think pay equals FLSA. Whenever you see compensation or wage issues, your first thought should be the Fair Labor Standards Act. Category 2. Leave. Is the employee requesting time off for a serious health condition, leave to care for a family member, bonding with a new child, or protected medical leave? Think leave equals FMLA. Remember, FMLA is about protected leave. Category 3. Disability and accommodation. Is the employee requesting help so they can continue performing their job? Examples include modified duties, schedule changes, ergonomic equipment, voice recognition software, additional breaks, or a specialized workstation. Think accommodation equals ADA. The ADA focuses on providing reasonable accommodations that enable qualified employees to perform the essential functions of their jobs. Category 4. Discrimination. Is someone being treated differently because of a protected characteristic, such as race, color, religion, sex, or national origin? Think Title VII. If the issue specifically involves age discrimination, think ADEA. If it involves unequal pay based on sex, think Equal Pay Act. Category 5. Workplace safety. Questions about unsafe working conditions, personal protective equipment, workplace hazards, OSHA inspections, or injury reporting? Think safety equals OSHA. Category 6. Military service. Does the situation involve National Guard service, military deployment, reserve duty, or returning service members? If so, think military service equals USERA. Here's another strategy that can save you points on the exam. Certification exams often include extra information that has nothing to do with the issue they're actually testing. Those details are red herrings. Don't chase every detail. Instead, ask yourself, what is the employee requesting? That answer usually points you toward the correct law. Some of the most challenging questions involve multiple employment laws, but here's the key. Usually, only one law is the best answer for the specific issue being tested. For example, an employee has exhausted 12 weeks of FMLA leave, but still can't return to work without restrictions. Many candidates immediately answer FMLA, but stop and ask, what is the employee asking for now? They may be requesting an accommodation that would allow them to return to work. Now the issue may have shifted. The best answer may be ADA. The law that applied at the beginning of the situation isn't always the law being tested at the end. Always pay attention to how the scenario evolves. Let's see how this works. Scenario 1. An employee reports that she was denied a position because of her religion. Pause for a second. Which category? Discrimination. That points us to Title VII. The issue is whether the employee was treated differently because of a protected characteristic. Scenario 2. An employee requests 12 weeks off following the birth of a child. What's the category? Leave. That points us to FMLA. The employee is requesting protected family leave. Scenario 3. An employee works 50 hours every week but never receives overtime pay. What's the category? Pay. That points us to FLSA. The core issue involves wages and overtime. See how much easier these questions become when you identify the HR issue before trying to identify the law? The next time you face an employment law question, don't panic. Don't start searching your memory for every employment law you've studied. Instead, ask yourself one simple question. What is the employee actually asking for? Is it pay, leave, accommodation, discrimination, safety, or military service? Once you've identified the issue, the correct law usually becomes much easier to recognize. That's exactly how experienced HR professionals approach these situations every day. And it's how successful certification candidates should approach the exam. Remember, don't start by identifying the law. Start by identifying the HR issue. Then identify the law that applies. If you need help preparing for your HR certification exam, join more than 100,000 HR professionals who have trusted HRCP to help them successfully prepare for their HR certification exams. Visit us at hrcp.com.